Good morning and good afternoon, everyone. We are waiting for our guests to join the session, and we will start in a couple of minutes. Folks are coming in, Jerry, so maybe we start maybe in a minute. We have 13 folks in now. All right. We're gonna begin. Good afternoon, everyone. My name is Pasha Ameli. I'm a managing director with Ancora in Washington, D.C., and have the pleasure of introducing today's Toolbox series speaker, Mr. John Jerry Glas. John is a partner and chair of the Civil Litigation Department at Deutsch Kerrigan in New Orleans and a fellow of the American College of Trial Lawyers. He has tried 114 civil or criminal trials, including 76 jury trials and 38 judge trials. Jerry has authored 3 peer-reviewed book chapters for the American Bar Association's popular From the Trenches series on trial strategy. He is also a frequent presenter, having lectured locally and nationally on jury selection, trial strategy, expert witnesses, traumatic brain injury cases, life care plans, and qualified immunity. He has also been an adjunct professor in trial practice at Loyola University New Orleans College of Law and has been a guest lecturer and teacher on trial topics at Tulane University School of Law, LSU Law School. Finally, he is the author of a new book published by the ABA called The New Science of Trial Advocacy, The Waiter Pivot. Without any further ado, I would like to pass on the session to John. Thank you for your presentation, John.
Thank you. Okay, so, it's only change. It doesn't matter who you are. So warned the prophet and British solo artist known as John Waite. And now change has come for us and for our profession. Look, we've known for a long time, right, that you can't try cases the way they do or they did in 1884. But what we're realizing now is that we can't try cases the same way we did in 2004. These jurors, our jurors, they're different. They know they're the most important people in the courtroom. They do not trust lawyers or their hand-picked experts. They, above all, do not want to be manipulated or told anything. You tell them something's clear and they will assume that it's not. You tell them something simple and they will resolve to find what you missed. And if you tell them to award a specific number, they will avoid that number like the bubonic plague. They are not your puppets, and they will reach their own verdict. Thank you very much. In fact, if you give some jurors nowadays the choice, they would tell the lawyers to pile up the evidence in the jury deliberation room and go home, get out of their way. Unless you're there to help. unless you're there to help them organize and wade through the evidence. Unless, like a good waiter, you're there just to bring them the evidence and the facts that they need, not cherry pick it, not spin it, not spoon feed it, just bring it to them. Then you can stay. And maybe they'll listen if you point out something about the soup. Forget direct advocacy. It's done. I don't know if it'll ever come back, but it's gone. They're done with mad dog litigators and used car salesmen. All they want are wonderful waiters, and that's exactly what we're going to give them. This paradigm shift in jury psychology, it is not a death sentence for our profession. It's an opportunity, right? It's an opportunity. All we have to do is take this opportunity to redefine ourselves in the courtroom, to literally reinvent ourselves as a profession. If we do that, right, then we can, without telling them what we want ever again, we can influence their deliberations. And isn't that exactly what we have always wanted to do? In order to do the waiter pivot, we literally have to change the way that we do trial advocacy. We have to rewrite the trial playbook. I'm talking about not small changes. I'm literally talking about the opposite of everything we were taught in law school, or at least I was taught in law school. And it starts with voir dire. Look, when we're talking about voir dire, I want you to consider the fact that you only get one chance to make a first impression. And the first impression that you get to make with jurors is what? The questions you ask in voir dire. So imagine if you're on a date and the first three questions you get from your date are, how much money do you make? What kind of car do you drive? Right? And where do you winter? Okay, so what would you conclude about your date? Well, the first impression that a lot of jurors get from us are the questions that we ask during voir dire. And we grew up being told that in voir dire, we should be asking questions that actually send the wrong message about us and our case, right? The questions that we typically ask are questions that reveal the kind of jurors that we fear, right? How many of you all hate trucking companies? How many of you all hate insurance companies, right? What kind of message does that send? If you're a plaintiff attorney, what kind of message does it send when you get up and you say, how many of you hate frivolous lawsuits? Why? Is this lawsuit frivolous? I believe we have to pivot to focusing not on the answers that we're getting, but on the questions themselves and what they reveal about us. Imagine if every question we asked sent the message that we want smart jurors. What would that tell them? That if we get smart jurors, we win. What if every question we asked revealed that we want people who are willing to roll up their sleeves and actually wade through thousands of pages of documents? What message would it send? That if you look at the documents prove we're right. It can be more than that. It's not just about us. It can also be about the case itself. We can frame the entire case. So in Shreveport, I did a jury trial in 2017 where it really was going to be a battle of experts. So in voir dire, knowing I only had a limited amount of time, I made sure that every question I asked had the word neurologist in it. How many of y'all ever worked for a neurologist, been to a neurologist, studied neurology? How many of you think that all neurologists are created equal? Can you consider the qualifications of a neurologist? So when I was done, an opening statement started, the jurors knew what this was about, who had the better neurologist. And that's how we framed the case, that this case is really about the best expert. Manufacturing defect case that I had in the Western District of Louisiana. The only claim left was manufacturing defect, and the plaintiff's argument was, hey, you know what? Your product's not supposed to do this, so raise ipsa loquitur. And I didn't want that to be even a possibility. So every question in the 15 minutes I was allowed by the federal court judge to voir dire had the word specifications in it. How many of y'all ever built something to specs? Ever had to decide whether something met specs? Ever been injured by something that deviated from specs? Specs for 15 minutes. So when we got up an opening statement and the plaintiff didn't identify how the product deviated from specifications, the trial was over. In 2021 in Houston, I did a jury trial for the plaintiff attorneys, parachuted in 2 months before. It was during COVID, so we're picking the jury in the NRG arena. You can see here a photo that we took right before we started. And the jurors had headsets and microphones, not the best scene. And it's the most boring topic in the history of the world, water transfer rights in North Dakota, right? So how do I make water transfer rights sexy? I wanted them to believe why we're there is it was a matter of principle. So every question I asked had the word written contract in it. How many of y'all ever had to write a contract? How many of y'all ever had somebody try to break a contract? How many of you ever had to enforce a written contract? How many of you think that we'd be better off as a society if we did away with written contracts and stoplights, right? By the time I was done, the defense counsel stood up, and the first question he said was, now, look, we like written contracts too, but what if a sentence can be written too? And before he said the next word, the jurors were already looking at each other like, oh, we get it. Jerry's here to enforce a written contract, and that's a good thing, and they're trying to wiggle out of it. It framed the entire trial in voir dire. Let's go to the next thing, right? Opening statement. What were we taught in law school? We were taught that you got to have something clever, right? You want to have a jingle or a theme or an analogy, something sexy that they'll remember. Stop doing that. Stop it. They don't want it. That's putting the spotlight on you and how clever you are. They don't want that. If you're a waiter, what should you do? You literally just get up and say, okay, right? Why? When the jurors walked into that courtroom, they had one question. That one question is, who's being unreasonable? They know the case is settled. So when they walk in, they're looking at us and they're saying, which side's being unreasonable? You better answer that question quickly or they're going to assume that it's you. So I think you have to pivot from these themes, these elaborate themes that we sit down and we spend hours trying to think of it, right? You sit down to write your opening statement and the first paragraph, you're sitting there, hours pass, seasons change, right? And you haven't come up with it. Stop beating yourself up. Get up and say, here's what we agree about. Here's what we don't agree about. What jurors really want from us, if it's not about us, is for us to get up and go, hold on, let me just explain the fork in the road, what you're here to decide. So in a jury trial I did exactly a year ago in November, I literally got up and said, look, we're not here because of the hangman's fracture or the spinal cord injury or the other orthopedic injuries. We're here because of their claim that the plaintiff, in addition to all those, sustained permanent brain damage. That's literally why we're here. And then I took it a step farther and I said, listen, these are the things that you're going to be asked to award at the end of this trial. We take 100% sole responsibility for the accident. They want $789,000 in past meds, give them every penny. They're going to tell you that he's entitled to $362,000 in past earnings, give him every penny. During opening statement, plaintiff counsel made a mistake, got up and actually gave them a number for future medical expenses that I could live with. It was actually the middle of their range. And so when he did that, I turned to my client and said, can I? And the client said, yes. I stood up, I said, they just told you that this young man's going to need $904,000 in future medicals. Give them every penny of it. So what are we, and that was literally, you can see in the transcript here, the third number was future medical expenses. We got the number this morning and we agree right now to pay that number. So I told them, you're literally going to spend the next 2 weeks, and this is what we're asking you to do. What we can't agree between the two of us is what's fair for future earnings and what's fair compensation for general damages. And the reason why we can't agree on it is because they say he sustained permanent brain damage and we say he didn't. I even told jurors that, look, I'm not going to, like a good waiter, right? I never say the word waiter, but I say, if they get all the facts you need from a witness, I'm not getting out of my chair, right? If I stand up, it's because there's a fact that I need to bring you that they didn't. You need to know, right? My goal is not to tell them what I want them to do. It's to make sure that they make an informed decision. Now that's counterintuitive. That's hard to do, but you can do it in the case. In this case, I said, if I get up, I'm not asking questions about hangman's fracture or permanent spinal cord damage. If I stand up, I'm there to ask a question to help you get what you need on the traumatic brain injury issue. It works for everything. I actually really like to frame the fork in the road when it's a legal issue. I prefer to use the scales of justice. I know a lot of people do as well. So the trial in 2021 in Houston, prior counsel, it was literally down to one sentence, right? Whether there was exclusivity. And prior counsel, who framed it as, yes, the contract requires exclusivity, or no, it doesn't, which is not the way to do it. Because when you frame it that way as a plaintiff attorney, the jury is going to be like, well, the language better be pretty clear. I framed it differently. I said, does this contract require them to buy all the water from us or not a drop? Which of course made no sense because the contract required us to invest 1.2 million. Why would we invest 1.2 million when they're not entitled to, or they're not obligated to buy a single drop of water? When I joined the firm 25 years ago, they told me that when it comes to defense attorneys, you want to get up and you want to challenge everything, right? Because you don't know what they're going to seize on. Don't do that. Stop doing that. You got to pivot from the shotgun approach to anchors. So the case I just used, here was our anchor question. After Lindale invested 1.2 million and brought the pipeline online, did the parties intend for Brigham to have the right to say, thank you, but I'm going to have all of my water trucked in? No. You can use an anchor timeline in a jury trial where there was 7 years of medical records and I parachuted into the case 1 month before trial. I told the jury, you're going to get lost in a sea of medical records and anecdotal stories and lost keys and lost temper. I'm going to give you an anchor, and the anchor is the first 7 months. And with the witnesses, I went through the first 7 months and established that the word concussion was not ever mentioned in the first 7 months, that all of the tests were negative, with our experts that there were no cranial nerve abnormalities, and there were no neurological deficits in those 7 months. So when I stood up in closing argument after the plaintiff asked for 18.5 million in a case in which we only had 11 million in insurance, I had this board literally behind me on an easel, right? 7 months anchor. This is not what you expect for permanent brain damage. And our exhibit book, far from the shotgun approach, right, literally was just the first 7 months of medical records. An anchor can be just a checklist, right? So we do a checklist that you can go through and you can say, look, I'm going to get you this information by the end of the trial. And it's the ER findings that really tell us as significant predictors of outcome following TBI. By the end of the trial, they'll see that column of no. They're not going to remember any one row, but they'll remember seeing a column of no. Pivot from hauling an expert to the stand in one sentence to say, no, the medication didn't change. No, roll up your sleeves and prepare a Rule 1006 summary like this. It allows you to take voluminous evidence and simplify it. As long as you provide it to opposing counsel and a chance for them to verify it, why have an expert say, trust me, the medication didn't change? Show it to them. Show them that the frequency, the amount, the dosage, all of it was the exact same for years before and immediately after the accident. And remember that Rule 1006 summaries can be in the form of timelines as well. In one trial, we wanted to show where the contract was breached was exactly when oil prices dropped, right? That's when they stopped complying with the contract because it wasn't favorable to them anymore. This is the toughest one. I'm very combative. I was trained, right, to, you fight with opposing counsel and sometimes you make it personal. Don't do it anymore. Now it's not about opposing counsel. Waiters aren't there to criticize other waiters for not having brought you out your, appetizer yet, or for not having brought you your bread, right? You don't criticize opposing counsel. You just do it. Just bring them what they need. So a trial in February was the ultimate test for me, and I almost failed it. I'm going to tell you right now, is that opposing counsel, plaintiff counsel got up in a case in which at a pizza restaurant, a metal grate swung down and slammed into this woman, the right side of her head. And he said, look at this ER record right here. Proof that she sustained just a horrible, horrific parietal injury to the right side of her head. Look at how the amount of the size of the skull that was taken up by this injury. And I knew that the counsel had made a real mistake. I mean, he had missed that it actually says no obvious injury. And what he hadn't done, which I had done, is I went and looked to see what those ER records look like from that hospital in other cases and for this plaintiff years before the accident. And sure enough, that wasn't a massive parietal injury. It was a hairline. It's part of the template for the human skull. So here's my choice. I get up and I'm telling you, 20 years ago, I'd have stood up and said, he misled you, he lied you. I would have criticized the other waiter. Not now. Not now. I take it as an opportunity to say, listen, that's an honest mistake. I understand why he would bring that fact to you or show that to you, but it's just the hairline. Let me show you here. This is before the accident, same ER. Here's after. You can see that's not a massive parietal injury. But I use it as an opportunity to say, hey, this is a great example of confirmation bias. Opposing counsel saw what he wanted to see because he was looking for evidence of brain damage. And the same is true of the plaintiff's experts. And I'll show you similarly when their confirmation bias has led them to interpret records incorrectly, right? Another thing that's very hard to do is that we've been taught to cross-examine experts, right? And I became a lawyer to the thought that I was going to win trials on cross-examination. Those days are over. These are not your grandfather's experts, especially in construction. They go to CLEs. They have more trial experience than you do. They know what you're going to ask before you ask it. And if you don't want to make the trial about you, and it's not about us anymore, pin, don't punch. Okay, it says here, pivot from punching to pinning. That's right. Pin, don't punch. The new written in stone rule is you don't win a trial with their experts, you win a trial with yours. So pin their lack of qualifications. Use a chart like this to show that theirs lacks the qualifications that yours does. Pin their opinions. In one trial, I literally just used this for my cross-examination and got plaintiff's expert to admit that her interpretation that the defendant's obligations were almost non-existent under the contract, right? I'm just checking for them. Yeah, look, I want to make sure you know these are 4 opinions that this expert has. Pin the admissions, right? You admit, here are 4 or 5 things you have to admit, and I check them off just to show the jury I am there to just methodically go through and make sure that they know what this witness admits, right? You can do that with, I love doing it with charts. Pin the incorrect testimony. So this was in a pro bono manslaughter trial where a police officer used a taser on somebody who, like 30 minutes later, and had enough, cocaine in him to kill a small elephant, has a heart attack, right? And they blame the taser. And so I asked their expert, what is the effect of the taser? And the expert incredulously says, it causes all the muscles to go soft. That's why you collapse. Which has the exact opposite effect, okay? I mean, I'm telling you, I've taken the taser hit to my back, the full 5-second ride. It actually contracts the muscles. So what do? 20 years ago, I would have been like, that is not correct. Isn't it true that it causes the muscle to contract? No. And I won't tell you the name of the expert because that would be indiscreet. It was Michael Baden, host of HBO's Autopsy. Anyway, but Michael Baden, when he says that, I just took a flip chart, wrote Baden at the top and said, causes muscles to become flaccid, and said, thank you very much, go home. Then I called my expert from Johns Hopkins Medical School to come over, and he says, that's ridiculous. That's the actual opposite effect, right? And the jury nodded their head. Why would I give him a chance to confront it? I had a paralysis case where the plaintiff's expert who wore blue jeans to the stand, so I called him Dr. Blue Jeans. Dr. Blue Jeans gets on the stand and he says, this paralysis was caused by the accident. It was not a coincidence. And I say, well, isn't there a test that would prove you're right? He says, yes. And it's a conclusive test, yes. And if that test was done and it was positive, then the defense would be correct, yes. And was it performed here? He says, no. I said, thank you very much, go home. Dr. Blue Jeans goes home. We call our expert to the stand. He says, well, I agree with everything except it was performed and it was high SFP. The defense is right. And the jury goes, why would I show their expert the result of that test like I would have 20 years ago? He'd look at it and go, actually, these results are kind of inconclusive, or, I don't know anything about this lab, or something. Why would I give him that chance? I send him home. I pin, I don't punch. What is the key? I am letting my expert win the trial, not myself. I'll even pin the overlooked evidence. In a trial in St. Louis, I literally took 2 boxes and put it in front of the jury. One was said yes and one said no. And I filled the box of no with everything their expert had not been provided. Do I go through that with their expert? No. Send him home, call my expert to the stand and say, let's go through what their expert wasn't provided. And I let my expert tell the jury why that's important. Look, when it comes to experts, I know my mantra, you don't win a trial with theirs, you win a trial with ours. And here's what I'm going to tell you. In law school, you were told that direct examination is like a well-choreographed dance, right? With your expert. Don't do that ever again. You can't do that. If every answer to your question is, that's absolutely correct, Mr. Glas, well said, you are right, the jury will ignore you and your expert. That well-choreographed dance, no. And don't woodshed your experts, right? Just stop. If your expert comes across as a used car salesman, God forbid your expert actually uses something you said, an opening statement or analogy you used or something like that, they're not going to believe a word he says after that. Turns out that an angry or grumpy expert is actually more trustworthy because they're not selling the jury anything. Don't dance with the expert. Sheldon from Big Bang Theory is not going to put up with a dumb question, and neither should yours. I had a cardiologist once be incredibly nice to me, my expert, almost grandfatherly, right? But then was incredibly mean to plaintiff counsel. I said, you can't do that. at trial. He goes, don't worry, I can be folksy. I said, you don't have that club in your bag. So you're going to be just as mean to me as you're going to be to plaintiff's counsel. And you know why? Because we are the dumbest residents you have ever had. Why are you acting like I know what I'm talking about? Right? It didn't matter if I stayed in a Holiday Inn Express last night. Sure enough, he got up on the stand. He couldn't have been any meaner to me or to opposing counsel. The jury loved him. Why? He wasn't there to sell him anything. Keep it simple, stupid. Every one of us was taught that. Good rule, great acronym, easy to remember. Don't forget the reason behind the rule. The reason behind the rule is to make sure jurors understand, but you can't just keep it simple. So if you're trying to prove that the current just goes between the two prongs of a taser, right? Show them more than just an analogy, right? I show them now the finite element model, right? That no one understands in the courtroom. Why? Because I'm telling them, remember, this guy has spent his life studying this. This bioelectrician knows a lot more than we're ever going to learn. Then show them something that explains where the current goes, that they can picture it, and then prove you're right. So I would, for example, I would tase a Coke can. I used to tase my watch until I missed once. It was very painful. And I made a sound that the jury found amusing. Anyway, the point is I go through and I don't just keep it simple, stupid, and show them the third. I do all three. I prove that the expert's smart. I explain why it makes sense, and I show them it. In that trial, the bailiff came up and said, you know, I've been figuring, I mean, tiny town. I've been figuring you've been right for the past 2 weeks, Mr. Glas, but I didn't get it till I saw that Coke can. I'm like, yes, we still need the Coke can, but we can't skip to it. You know, the last kind of thing I'll just tell you about closing argument is that closing argument has to be different. It is not just getting up and showing them your side of the evidence, discuss all of it. So put all of the evidence on the scale. I literally, in the trial that I mentioned in Houston, I went through all of the evidence on the scale, including pictures I took of our witnesses, by the way, during the break so that the jury could remember what they were wearing or what they looked like. I went through all of it as if I was in the jury deliberation room with them, and the jury was only out for an hour because I had done what they were about to go through. And they came back with a verdict of 26 million. You know, I don't tell them my opinions. I focus on their decisions. I never give them a number. I give them a range. So as a plaintiff attorney, I gave them this range of 27.1 to 27.9. The jury, wanting to be fair, awarded the bottom of my range to the penny. I identify a turning point, right? Every war has a turning point. Every football game has a turning point. Every romance has a turning point. So similarly, tell them the turning point in the trial, and they'll start calling that in jury deliberations, right? The turning point was when this witness said that. They will talk about the turning point. It'll be a self-fulfilling prophecy. And last but not least, do not run from prejudice. I divide all my jurors into lions and lambs. And during mock trial, I keep a separate tablet where I write down everything prejudicial they say. And in closing argument, with the client's permission, I will say to them, look, if someone starts saying who's going to take care of the plaintiff, they've stopped weighing the evidence. If someone says this is the price of doing business, they've stopped weighing the evidence. If somebody gets emotional, what I'm doing is I'm preparing the lions to gobble up the lambs. Imagine if the judge said, you can't talk about the evidence in closing. We would spend that time wanting to help coach the friendly lions how to handle and respond to questions. So the last example I'll give you is a case that I got up and I said in closing argument, you know, at some point, someone is going to say, let's split the baby. That's Solomon-like wisdom, right? But the real wisdom of Solomon is that he didn't split the baby. He gave the whole baby to the woman who deserved the whole baby, and he gave no baby, not even a hair, to the woman who didn't. Justice is not splitting the baby. We don't need a jury to decide what the midpoint between us is. Justice is figuring out what the accident actually caused. And the jury actually hung up on that. They never got past the first question, did the accident cause any injury? That would not have happened, that moment, if we had not used closing argument to less tell them about how we've been right all along and just argue our points, but to also help prepare them for closing argument. I wanted to stop and leave a little time for questions. Are there any, Pasha?
No, I don't see any questions coming in. We have a few minutes for questions. You want to come in? And so, John, I have one question for you. Having testified in a jury trial, what I observed is the other side, during the cross, the other attorneys approach can also affect the jury's kind of maybe facial expressions or maybe decision in to some extent. What do you have to say for folks who experience that when there is a rush of maybe a strong response from the other side in a jury trial? How do you suggest they should handle that?
Great question. Okay, so a couple of things. One is that when plaintiff's counsel has a very emotional response or something like that, in closing, I keep a list of it. I keep a list of prejudicial things they say during the trial, jabs at us, things like that. And in closing argument, I'll say, look, one side has spent the last 2 weeks just making sure that you had all of the facts that you needed. And the other has been very emotional, passionate, has instead of having you focus on the evidence, they tried to distract you and have you focus on us. It's not about us, never has been, right? Sometimes I'll say one side is focused on emotion, one side's brought you emotion, our side's brought you evidence. I won't even say our side. I'll say one side's brought you emotion, one side's brought you evidence. One side has appealed to passion, one side's appealed to logic. And what I'm emphasizing to them, right, is if you look at the depictions of Lady Justice, they always have two things in common, Pasha. And what are those two things? Always blindfolded, always holding the scales of justice, right? Because it doesn't matter who's in front of them, whether it's a giant corporation or a mom and pop grocery store or an individual. The only thing that matters is the evidence that's on the scale. But you got to practice what you preach. So when someone says something outrageous or untrue on the stand, a witness, I don't go, what? I don't. I have shifted, I've pivoted to like a good waiter who you've just asked the good waiter to bring you 12 more, dishes or something. I don't get angry. I just go, so the shoulders slump for me, right? So the witness says, I have never been in that store and I've got video of it. I go, okay. And I go back and I get the video and I show it to him. And I asked, so once I had to impeach someone like over 30 times in the course of 4 hours. And each time I didn't get angry or build it up to a feverish pitch. Each time I go, okay, and I'd go and get the record. And so the jury got to know that by the 10th time I go, okay. And I'm like, I got more work to do for the jury, right? And they'd be like, here we go again. But my rule is let the jury get frustrated with the witness before you do. Why would I deprive the jury the chance to say, oh my gosh, this witness is lying? They need to conclude it before I say it in closing, right? Not that I ever will. I'll just point out all of the things. Right? If I don't want to call your husband lazy, right? But if you have a friend, you want to open their eyes, you say, so let me just get this straight. I mean, he stays on the sofa all day. He only watches Harry Potter. I love Harry Potter, so I'm gonna use that example. That's what, if I could, I'd sit on a sofa all day and watch Harry Potter. Do those things. You just point out the facts because your friend's the one that has to reach that decision. You can't tell your friend that their husband's lazy. You just help them, bring them enough facts that they'll reach that conclusion on their own. And that's the new art. And the real challenge is the fine line between a waiter that cares about the verdict and cares to bring you everything, and one that seems almost apathetic. So you can't cross that line and have a jury be like, the defense counsel, he didn't seem to even care about it. Like he's just going through the motions. You don't want to have gone that far where you're a disinterested waiter, right? But you don't want to make it about yourself. You shine the spotlight on the witnesses and not on you. I'll give you the last best example is that during a direct of an expert, I will actually intentionally make mistakes that will allow the expert to correct me in front of the jury. Now, like not stupid mistakes. I'm not gonna play a fool, but I will ask questions that I asked when I first met with the expert, where the expert's like, Jerry, you're not even asking really the right question. You should be asking me this. Why? I'm giving the expert a chance to establish their superiority and their independence from me, right? What's the turning point in the movie My Cousin Vinny? It's when he shows her the photo and says, does the defense's case hold water? And she says, no, the defense is wrong, right? Everybody goes, ooh, because nobody expects someone you call to the stand to tell you you're wrong. So I will actually, instead of a well choreographed dance, I will kind of have more of a wrestling match, right? But what I'm really doing is I'm recreating that first meeting where I went from being dumb to knowing enough to be dangerous. Why would I have them skip that step? Does that answer your question?
It does. It does. And I hope that we can hear more about those in the ABA Trial Academy at some point. I'm sure everybody will enjoy that. Um, I haven't seen any questions coming in, but if you could kindly offer your time, maybe folks could reach out to you through LinkedIn or emails if they have any questions. That would be fantastic.
Yeah, so it's Jerry at deutschkerrigan.com. And feel free to email me any questions you have. I live to talk about this, and I'm still learning, right? So the book, The New Science of Trial Advocacy, The Waiter Pivot, I will tell you that this change, I'm not the first one to notice it. I think all of you have probably heard at least one strategy here that you've all personally used at some point. That's because when change happens, it happens everywhere. Rick Friedman wrote a fantastic book called The Way of the Trial Lawyer. He's a plaintiff attorney. He's one of the inner circle, right? So one plaintiff attorney in each state. And his book is noticing the exact same shift in jury psychology and how, in terms of professionalism and ethics and dealing with counsel in front of the jury, it's like the missing chapter from my book. It's the perfect complement to it. My book's really more about specific trial strategies. How do you change opening statement? How do you change? Should you object? I mean, I just did a trial where I did not object once. Why? Because jurors want to be trusted with all the evidence. And you don't want to be a lawyering lawyer who the first thing they hear you say is an objection. In fact, my rule is if you don't win your first two objections as my co-counsel, you don't try the next case with me, okay? Because I want to change their mentality from I should object to everything to I better have a really slam dunk evidentiary reason to object, or to preserve the record. So, I think probably you're going to see this change everywhere. I've heard some people now saying that they think that the waiter pivot is one way, just one way to adapt to these nuclear verdicts. That not all the time, there's a lot of things that are responsible for nuclear verdicts, but sometimes people believe, I've heard panelists talking about this now, that one of the reasons why we're seeing nuclear verdicts is because we've got these modern jurors, and some people are getting up and still doing the old approach. So we just had one of the largest verdicts in Louisiana history in Opelousas, Louisiana, like a $230 million verdict. I was in that case. We tendered our limits like almost immediately because I knew it was worth more than the 12 million. I think we were 5 excess of 7. But the attorneys who decided to try that case were still challenging everything, right? And called 2 experts to the stand to say that the plaintiff was a malingerer when the plaintiff had already been interdicted, right? What is that? No wonder the jury got angry. No wonder the jury awarded so much money. So the waiter pivot, taking us out of the equation, you're taking some of the poison out of the case. I mean, the jury, you're asking them to fairly and objectively weigh the evidence, and you're not doing anything during the trial that makes the case about sending you as an attorney the message. Last thing I'll say is I did a mock trial in September, and the first juror to speak during the mock trials to agree with any attorney started out by saying, look, I don't agree with everything that plaintiff attorney said, but I do agree with one thing. That's the point we've reached. And if everyone doesn't realize that, now's the time to realize it, is that jurors do not want to appear even to agree or have been persuaded by the attorney. They will literally say that disclaimer before agreeing. So why would we ever want to make the trial about us? Why would we identify a number as our number? Why would we call bobblehead experts? It's all got to change. I'm going to tell you right now, there are people who are saying, oh, someday lawyers will be replaced by AI. And the jurors will use, in the deliberation room, AI to search the records and find things like that. We need to have redefined ourselves before that time as someone who's indispensable, because there's no way you could wade through this evidence without me. I've spent years figuring out ways to simplify this and go through it with you to make your job just a little bit easier. So I'll say that the original title of the book, which the ABA rejected, was Kill the Lawyers, Tip Your Waiters. Okay, and I get it. We don't want to have a book that says kill the lawyers, but kill the lawyers, tip your waiters. And they rejected that. I understand why, but there's a natural connotation that when you say kill the lawyers, people don't understand the irony of Shakespeare, and they go, yeah, we should. And when it comes to tip your waiters, you're like, yeah, of course we do, right? People reward a good waiter. And if you've ever been a waiter, you know that a good waiter can absolutely influence every part of a person's dining experience and can influence, right? You don't get up and you go, welcome to the restaurant. I'm telling you right now, you're all ordering specials. That's what lawyers have done for generations. We now have to say, hi, I'm now going to describe the different entrees in a way that I know what you're going to pick by the time I'm done.
Mhm.
That's the new art. And I'm not saying I always do it well. I don't. But that's the new challenge.
That comes with a lot of experience. I think that's how you get to that point. So
It comes with a lot
thank
of
you.
trial and error.
Yeah, thank you for sharing it with us. I can see in the chat box that multiple individuals are expressing how the great the presentation was, and they're thanking you for your insights. I echo that sentiment. Thank you again. And to our audience, this session is recorded. If you need to revisit this session, please reach out to the Forum Division 1, and we can provide that to you. And if you are interested in participating in the future presentations, please also reach out to us. John, thank you again for your time and the insights. I really appreciate it.
Thank you, Pasha. Good luck, everybody.
Bye-bye.